It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some girl with beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a 22 and shoot herself in the head in front of her significant other without a statement. We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. This state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Scheuer appearing in person in custody with counsel Glenn Keene. We're set here today in this matter for a sentencing hearing after revocation. Mr. Scheuer was placed on probation after he pled guilty back on September 3rd, 2024 to 1 count of possession of a firearm by a convicted felon. 3 days after he was placed on probation, he was put into custody for another serious offense in which he was just recently sentenced. He was revoked on this matter due to the allegations and matters in the case that he was just previously sentenced. This matter was set for a revocation sentencing. The court has received and reviewed the revocation order and warrant packet from the Department of Corrections. I have reviewed such packet, and in my review, I could not see any material facts or statements that need to be clarified on the record. But again, I don't know all of the information that the attorneys know to be able to have those material facts and corrections jump out at me. Ms. Rockow, as Assistant District Attorney, are we in victims' rights compliance?
Yes.
Did you review the revocation order and packet in order?
I did.
Any material facts or statements that need to be corrected on the record?
No, Judge.
Is there going to be a victim impact statement made here today?
No.
Okay. Mr. Keene, did you receive and review the revocation order and recommendation packet?
Yes, Your Honor, and there are no facts in there that I believe need to be corrected.
Did you review that thoroughly with Mr. Scheuer?
Yes, Your Honor.
And he did not discover or find any material facts or information that should be corrected on the record?
But no, Your Honor.
Okay. All right. Thank you. Ms. Rockow, please begin your sentencing argument and recommendation.
Thank you, Judge. The state respectfully recommends that Mr. Scheuer be sentenced to the state prison system for a total of 4 years, with 2 years of initial confinement, 2 years of extended supervision. That is in line with the recommendation that was outlined in the PSI by the department. As the court's aware, we are to consider the Galleon factors here in determining an appropriate sentence for Mr. Scheuer. The state's position is that Mr. Scheuer must be sentenced to prison based upon the factors. As far as the gravity of the offense, possession of a firearm by a felon is very serious. The legislature indeed has deemed this a Class G felony with a maximum possible penalty of 10 years. It's a crime that poses a serious risk to public safety. This crime in particular, the underlying facts of this case warrant a prison sentence. Mr. Scheuer was at sentencing, there were 4 other counts that were dismissed but read in, including 3 counts of possession of a firearm by a felon in addition to this conviction. There were 4 total rifles that were in Mr. Scheuer's possession at the time of this incident. And on the date of that arrest, he admitted, and in fact, one was in his direct control, very nearby to him, and he had admitted to law enforcement to having handled that firearm in particular on that date. He also had a knife concealed in his possession. So this is an inherently serious crime, and the facts are also quite serious in this case. In terms of the character of the defendant, again, inherent in this crime is an indication that the defendant has no regard for the law. He's a convicted felon, not allowed to possess firearms, and he did so anyway. His criminal history reflects convictions dating back to the early 2000s. He has a fairly extensive history. His history does include violent offenses, convictions for battery, simple battery and substantial battery, violations of domestic abuse, no contact orders, also includes recklessly endangering safety, and multiple convictions for bail jumping. I'll also note that there's a 2014 conviction out of Minnesota for possessing a pistol or assault weapon. The need to protect the public is the last factor for the court to consider. And I think that there's an obvious need to protect the public from Mr. Scheuer. A convicted felon with a violent criminal history who shows no regard for the law, no regard for court orders, or for the public, or for public safety. His actions that led to the revocation obviously include more violence, more disregard for public safety and for the law. I think anything other than a commitment to the state prison system would unduly depreciate the seriousness of the offense and the conviction here. And I do think, in fact, prison is necessary to protect the public in this case. Thank you.
All right. Mr. Keem.
Your Honor, I do have one character witness for him. It's his son, Brandon Scheuer, who's here in court.
All right, Mr. Scheuer, you can come have a seat over at the black table, and you can state your name and spell it for the record.
Hello, hear me? My name is Brandon Scheuer. It's BRANDON SCHEUER.
You may begin.
Where do you want me to start? Glenn?
Well,
Nope, you just.
whatever you talked about.
Oh, whatever to talk about.
Yeah.
All right, well, I'll start off by saying that, I do think that violent criminals should be in prison. I don't think my dad's a violent criminal. I think that he has mental health issues that were never addressed for the last 20 years. And I do believe alcoholism amplifies those. And I believe getting mental health would help him dramatically. In the case of this issue, I could tell my father was a different person after the suicide. My father always had like a clean counter, dishes always done, up early. I would not hear from him for a couple of days after the incident. I would go check on him. He would still be in bed with a giant body pillow, counter trash, sink full of dishes, just completely not his character. And I believe that was just more depression. And I think that his depression and his mental health issues have never been addressed. And he's constantly been incarcerated and never gotten help that he's needed. And I think getting him the help he needs is a big step. Is he going to have to be in prison? Yes. But just locking him up isn't going to help him. He needs to get help. And I wish the court system would help more people in this case. It's an epidemic in this country where people are just locked away when they have issues and we don't address the mental health issues that we need to address. 3 of those guns that were locked in the shed on the day of that incident were mine for deer hunting. I had them locked in that shed. I believed I had the only key to that shed. I was unaware there was a second key. The .22 firearm that was used in the incident, to my knowledge, was used for protection against bears as they were living in my camper on his 40 acres. When Crystal and my father first started staying on the 40, they were staying in a tent. They had bears tear the tent, tear the coolers. I gave them my camper to stay in as a safety option. Other than that, the only real things I have to say is that I believe that this country has a problem with just locking people up and throwing them away. And I think that we need to address mental health issues more and more in this country. And this case in particular, he's had 20 years where he's never had that addressed. And he grew up at a time where when people had mental health issues, they really didn't talk about it or get addressed. And I believe most of his issues stemmed after the divorce with my mother in 2003. His alcoholism, which he hadn't drank in many years, had kicked off and came back into his life and continued to amplify those mental health issues. Because when people are depressed, the drinking don't help that. All it does is amplify those issues. And that was never, ever addressed in over 20 years of him being in and out of the system. That being said, I can't quite think of too much other things to say. I know my father is a very good person when he's not drinking. He has donated his time to my business during the parades and other things, and to help me with working with kids in the community for kayaking. He cuts and splits wood. He has helped friends of mine who needed trees removed or other things on their property done come over without even being paid to help out, just to be a good Samaritan. So I know there's good in him. We're not unlocking the good. We're locking the good up with the bad. Where we should lock the bad up and unlock that good. And the only way that is to use, mental health therapy and other sorts of programs to get to the root of the problem. I went through therapy because of you, Judge, and I continue to do that therapy for a while after the things we had with the things I did to get back, and it helped me very much. I'd come creating new programs to help myself hydrate more, things like that, getting better eating schedules, just slight things to add more consistency to life and a more routine schedule. And I think, that helps a lot of people. And it's something I needed just slightly to help my life. But there's a lot of people that need a lot more than that. And they need that intense mental care. And that's something this country has gotten far, far away from. And I hope we get back to it.
Thank you, Mr. Scheuer.
Thank you, Your Honor.
All right. Mr. Keen.
Yes, sir. When we look at this case and sentencing and the factors, I think a couple of things to note. Well, I won't dispute the seriousness of the crimes because Mr. Scheuer does have a lengthy criminal record. Most of it is for, substance abuse related issues, but you've seen it on pages 24 and 25. So, I won't dispute that. However, when you look at the character of the defendant, I would note that when you look at the offenses that day, his son had just talked about how, the 3 of the firearms were his, and it was, a place to hunt in the 40 acres. And he said that they were encased. I would note that my client on the day he was charged, had contacted law enforcement. He, pointed out, the weapon was not in, was set by the vehicle when law enforcement arrived. He's not brandishing it. And his son had just testified that the 22 was, for, protection for bears. A 22 isn't usually a weapon if you're going to try and rob somebody, a 22 isn't your first choice. And regarding the dismissed and read in on the concealed knife, it's a 40-acre property, and he had it. There was nothing about him threatening to use it.
But I'm hearing excuses. He's a felon. He's a felon, a convicted felon, and I'm hearing excuses. Even in your defense argument, they're excuses.
I'd see them as mitigating factors rather than excuses.
There's other things to use to protect against bears. I've done it myself. I've grown up in bear country myself. I don't carry a 22 or a knife. There's bear spray. There's crossbows. There's other things that felons can use and carry. It's an excuse.
Well, and these guys, the firearm was owned by the person who lived there, not him. But I get that when you live with you're a felon, and the person you live with has a firearm, it tends to put you in an untenable situation.
And he admitted to operating it.
Right, moving it. Okay. But I think we did point out in needs is that, the alcohol and counseling needs, and he did talk about one of the things looking at revoked is that unfortunately mental health needs did increase after that because his son did describe change in my client's behavior after his then girlfriend, unfortunately, took her own life that day. And, that obviously contributes to a downward spiral as well. And I would note that, when you look at protection of the public, I would note that, he already, for the offense he was, convicted, pled to in this court, he already had a 9-month sentence. And I think that, allowing him to be closer to his son and the community would probably do more in the long term to protect the community than than just simply warehousing him again, which is what his son was saying. Because, it had access to, counseling and other needs. So the offense thinks that, a reasonable sentence would be 9 months of custody, because he already has a 9-month sentence in 24 CF 202. So if you sentence him consecutive to that, then he's still closer to his family and other things and hopefully could address his needs. And, if he qualified for Huber, he'd be in a confined setting because obviously if you're, having to go to and from jail or report on monitor, that would be a way of ensuring sobriety because when for the charge he was revoked, he admitted to having alcohol that day. So having additional time where, if he qualified for Huber and in the community, he could, potentially get counseling. He could be working. He would be monitored on a continuous basis to ensure that he's not having access to alcohol versus just, adding more time to prison than when he gets out. It's back to the same supervision that obviously hasn't worked. So I think if you look at those two sentences, because they're both really the same action, you'd be looking at 18 months total custody he would have had. And I think that would promote more to protect the community while reflecting on the mixed character of Mr. Schuer than just simply, tacking on a few more years in prison. And failing that, obviously, you would ask that he at least be eligible for the earned release program and substance abuse. Take care. What I'm saying is if you disagree with our suggestion, obviously one of the decisions you'd have to look at is whether or not he would be eligible for.
He wouldn't be eligible for the challenge incarceration.
No, I'm talking about, no, I'm not talking about challenge incarceration.
For the substance abuse
Right,
program.
yes.
Right. Okay.
Right, no, I'm aware that, he's 2.5 decades too old for challenge incarceration program.
All right. All right, thank you. Mr. Scheuer, now is going to be your opportunity to tell me your side of the case, if you wish to, anything that you would like me to know about this case, about this matter, about yourself. I have read the department's revocation packet, which does include a lot of information, and it includes the decision by the ALJ, the alternate, or the administrative law judge in the revocation, as well as a few bits of other information. You can tell me whatever you wish to tell me right now, or you don't have to tell me anything.
Well, I'm going to tell you one thing, that the gun was for her. It wasn't for me. It was for her protection. She was a girl from the cities and she was afraid of the bear. The gun was given to her for her own protection. And it was supposed to be locked in her storage shed, and she had the only key for that storage shed. I don't know how the gun got, obviously she went and got the gun, plain and simple. I didn't know, I was at work and she dropped me off because I worked at the 10th hole, and she dropped me off and then she picked me up. And then when we went home, that's when she went in and brought the gun out, plain and simple. But otherwise, yes, I myself believe I have post-traumatic stress. I was in shock. I never would want to witness anything like this in my life again. I feel sorry for Bets going to war and watching people die. I love that woman. Loved her to death. I moved a gun till the gun fell on her. It's the only reason I moved it. I didn't know if she was gonna shoot me. I didn't have a clue. It's the only reason I moved that gun. The other guns I didn't know nothing about. Yes, I had a key. I had a key in my key ring, but I hadn't gone into the shed. I haven't wasn't in the shed for days. And it was 2 days before deer hunting. That's all I know. And the guns that were in the storage, in her storage shed. And I know my son deer hunts and he was supposed to have friends come over that didn't have guns and they were gonna hunt. There was no bullets, nothing there. There was absolutely nothing to fire out of them guns that were in that shed. Absolutely, there was just guns. That's all it was, guns and gun cases. And I knew nothing about them. I knew about the 22 that she had because she asked for permission and she got the gun from my son for her own protection when she was there by herself. That's what it was supposed to be for. And like I said, I only moved the gun when she shot herself and hit the ground. That's why I moved it and I leaned it up against the car that was in front of it. Like my son said, I help him a lot. I help a lot of people. If you even ask the jailers here, I'm cleaning all the time. I ask to move to different cells just to go clean them because they're not clean. I help a lot of people. I buy canteen for people. I'm not a violent person. Yes, I do have mental issues. And with that, yeah, I probably had drank. I started alcohol. I was sober for 24 years. My kids grew up with a sober father because my father was an alcoholic. So when my kids grew up, I didn't drink. But when my wife divorced me and I ran through the coals, I started drinking. That's when I started drinking in 2006. If you look at the records, that's when all my problems started. And with that, that's all I got to say. I wouldn't harm anybody. I wouldn't kill anybody in my life. Like I said, I wouldn't want to go to war. And with that, it's.
How many sheds were on that property?
Huh?
How many sheds were on that property?
One.
I just got multiple stories about the key or who had keys and who had access with that. First, you said she was the only one that had a key.
No, that was her storage shed in town. She had a storage shed in town with all her stuff, and she was the only one with a key for that shed. That's where the guns were stored, was in the shed in town.
That's where your son's guns were stored?
Yes, the guns that ended up on the property were in that shed.
All of the guns that ended up on your property where you resided in that camper were originally in a storage shed in town,
Yes,
but somehow they ended up all on your property on the camper.
because deer hunting was coming and she brought them for my son to go deer hunting. That's how they ended up there. Because it was 3 days before gun season. 2 or 3 days before gun season. It was on a Wednesday. And they were getting ready to go deer hunting.
And then they were placed in another shed that you had the key.
That a key was on my key ring, yes.
So you,
But I didn't know the guns were in the shed. I wasn't home when the guns were put there.
then how did they get into the shed if you?
I'm
had the
assuming
key?
Crystal brought them over for my son to go deer hunting.
But if you were the only one with the key,
No, I wasn't the shed at my house. No, I wasn't the only one with a key.
I wrote it down. You said I was the only one. I was on my key ring.
No, that's not true. I had a key and there was 2 other keys for the lock because the lock was for the shed and for the chain that went across my driveway down on the end. My son had a key to the shed.
I heard that and I knew that it was his property.
No, the camper is his. The property belongs to me.
40 acres is yours.
Yes,
And he brought the camper for you. So the
yes,
shed is yours.
yes,
The guns in the shed were not yours, but you had the guns in your shed.
yes.
Where
The
the
guns
key
were put in the
shed.
shed, correct. On a Wednesday, and then deer hunting was Saturday. but there was no ammunition for the guns.
Were you and the victim fighting that day?
No. No,
You weren't drinking together at the 10th hole and fighting?
no. No,
Then what happened that day? What happened where she picked you up?
Crystal
from the
was
10th
a
hole?
very depressed person. She was on a lot of medication and she was from Minnesota and she was losing all her medication. She put money in the bank, which I had to, remember when I signed the check for forgery and we got all that settled? Because she had a check that she went to the bank down here in Simon and was gonna deposit because she didn't have an address. So she went down to the bank, Bremer's Bank, isn't it Bremer's Bank down there? And tried to put that check into the bank. And they told her they wouldn't accept it because she didn't have a permanent address. So she went to US Bank, which her and I had an account together. But then she moved back to Minnesota for her medication to a Jeannie, and I can't pronounce her last name's house, and changed her mailing address. That's how Crystal's daughter got the statements for the bank, which she put the money in US Bank, and US Bank wouldn't let her take the money out because she couldn't establish a address.
So again, I don't understand how this happened because here we have a day, okay,
Yes,
where we have the victim dropping you off at the 10th hole to work.
yes,
And then you
in the
said,
morning. And then she went to the food shelf to help at the food shelf.
can you let me talk,
Yes.
please? And then she dropped you off at the 10th hole
Yes,
and she went back and did whatever she was gonna do that day.
yes,
And then she picked you up from work at the 10th hole. And you're telling me she didn't have any drinks or alcohol.
yes, she did.
So she sat and she drank for a while.
No, she had one drink. She had a Bloody Mary.
She had a Bloody Mary. And she picked you up. Did you have anything to drink that day?
No,
So you didn't drink. She had a drink. She picked you up. She brought you back to the camper. You weren't fighting. There was no negativity between the both of you. You get back to the campsite, to your camper, where you both have resided and lived for a significant period of time. And then all of a sudden, out of nowhere, she grabs a 22, runs in front of the camper or the truck and shoots herself in the head. That's what happened. That's what I'm hearing.
no.
Nothing happened that caused this.
When we were at the 10th hole, there was a girl in there that had black curly hair like Crystal used to have. She used to have long black curly hair. Well, she cut all her hair off and it was pure white. It turned gray. Well, this girl had the same kind of hair that Crystal had and she had a low cut shirt. And when she went by, Crystal said, "Look at her hair." And I said, "Yeah, it's pretty." And I said, "She's got a nice cleavage too," because her cleavage was hanging out. And Crystal used to be the same way. Well, the girl next to Crystal turned to her and said, "Well, I'd like to do something with my hair." So I think one reason was that depressed her because her hair was cut off and it wasn't what it used to be. Crystal committed suicide more than once. I saved Crystal twice before this. One time she took a bunch of pills when we were living in Burnsville.
It just doesn't make sense. It doesn't make sense.
She was a depressed person.
Respectfully, I think we're getting a little, we're simultaneously for having a firearm, and now it seems like the court is moving to trying to investigate.
What he did though, was he messed with the crime scene. By touching a gun, he messed with the crime scene. I'm not trying to go into anything. There were allegations or there was discussion on whether or not there were facts for a homicide, Mr. Keene, before you were even involved. That was part of a plea deal with the original attorney that homicide would be forever off the table as part of the plea deal. The court said that can't happen. That's against public interest. That
Right.
can't occur. So then that was removed as a plea deal. So the court's trying to understand here. I'm trying to get an understanding of how this could even happen. He knew that there was a firearm, a 22.
No, I didn't.
You didn't?
No, I didn't know it was there. The same with the other guns. That day, she must have went and got them and took them there.
And with the bears there, you had no clue that there was a 22.
Yes, but the gun was still stored because the bears weren't around anymore.
You just said you didn't know that there was a gun, but yes, you knew that there was a gun, but it was stored somewhere. So there weren't bears there anymore. There's always bears. We're in bear country.
I realize that.
None of these, I'm just saying, Mr. Keene, none of his statements, none of his facts connect. That's what I'm saying.
Your
And
Honor,
I'm
it seems
trying to connect the facts. That's what I'm trying to do. Is he here for a sentencing of homicide? He is not, Mr. Keene. He is here for possessing a firearm as a felon.
Yes, sir.
And that's possessing is knowing there is a firearm in your ability to have possession of that firearm. I'm trying to connect the facts. It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some girl with beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a 22 and shoot herself in the head in front of her significant other without a statement made. It makes no sense. And then the defendant altered a crime scene. He manipulated a crime scene by taking a gun from a person who apparently, allegedly committed suicide. He took a gun and moved a weapon. He touched evidence. You do not touch a crime scene, whether it is determined a suicide or it is determined to be a homicide is not for Mr. Scheuer to determine. It is for the police to determine, and they were not given an opportunity to make any determination, and because he altered it. He altered the evidence.
There are people panic at various times and react in.
Exactly, but they cannot touch evidence in a scene. And here's the thing, again, we're digressing. I'm getting to trying to figure out that day and what happened and why we are here and what I am sentencing for. It is not simply a felon possessing a firearm. And as you stated, and that was part of your argument, there's bears. So you need a gun to protect yourself from bears. And that's why he had the knife, because he needed to protect himself from the bears.
The knife, the knife wasn't about the bears. It was just, if you're on a working property, a 40-acre property, you're probably going to carry a knife, have a knife on your property in the country. I mean, make cut branches, whatever. Just making a point that although it was a dismissed and read charge, there's a difference between carrying a knife in town and around people versus having one on your own property.
I get that and I understand that. But again, that's where I'm trying to connect the dots and I'm trying to see where we are, because as you can probably gather, this is a very serious case. You're arguing to have him released and just have him sentenced on the case that he was sentenced to, which again was very serious and serious domestic.
My argument was that since you'd already ordered that one to be consecutive, I was suggesting for a 9 months county sentence, because you'd already in 24 CF 202, you had declared that one to be consecutive to other cases. So I wasn't suggesting that the court, go from 2 to 3 years in prison as the DOC recommended, or the state's recommendation of 2 years in prison to, in essence, time served. I was arguing that, an additional 9 months in county jail that was consecutive to 24 CF 202 would be an appropriate sentence for
18 months of jail. And then otherwise we have the recommendation from the state of 2 years in prison and 2 years of extended supervision, or the recommendation of Department of Corrections for 2 to 3 years in prison and 2 to 3 years of extended supervision, and or the maximum possible penalty of up to 5 years in prison and 5 years of extended supervision. When we look at this case, and again, this is why I have to connect the dots and see what happened. And I'm not looking at this as a homicide. I can't do that. That is not what this is. But again, I do have to look at all of the facts.
I want to
as
know
they
why
occurred.
she did it too.
All of the facts as they occurred that day. Every single fact. And I have to determine credibility and whether or not I believe Mr. Scheuer that he says he did not know there was a firearm. And I'm hearing contradictory statements. That's why I ask the questions, Mr. Keene. That's why I ask the questions again in a different way and then again in a different way. And that's why I asked to connect the dots. Because one time I get one answer, one time I get another answer, when it really is the same question, just asked a little bit in a different way. Stop. So when I'm looking at this case, and originally you're looking at this case, he was charged with 5 crimes, 4 very serious felonies, up to maximum possible penalty of 10 years in prison for those 4 felonies. And a misdemeanor, up to 9 months of incarceration for that. Part of this plea agreement, this working the deal out with the state, you got a really good deal here because the agreement called for pleading guilty to the 1 possession of a firearm as a convicted felon, and the rest would be dismissed and read in. So the maximum possible penalty hanging over your head is no longer 40 years and 9 months. It's 10 years. So 5 in, 5 out. So that's a pretty good deal. Considering the facts and all that led to it. Because again, you could have been charged with altering a crime scene. There could have been other things that could have been charged here. But you weren't. And I understand where Mr. Scheuer is coming from that day of stating that the victim killed herself, took her own life that day. Again, I'm trying to wrap my head around what happened and why it happened or how it happened. With the facts I have, I can't. But what I have to wrap my head around is the actual charge that I have in front of me and that conviction, possession of a firearm, convicted felon. I do believe that you knew that she had that 22. I fully believe you knew she had that 22. I fully believe that you had access to that if you wanted to. You were in a very significant relationship. As you said, you loved her dearly. You seriously loved her dearly. I don't know if you love her now. I don't know if that was your statement. And you're showing emotion as to her death. And I believe your son, Brandon, when he says that he sees mental health issues in you. I fully believe it. And I remember Brandon a little bit from a few years ago. I haven't seen him in front of me, so I'm going to guess that he's done a lot of good things with his life and he's made changes and he's doing well. I believe him when he's saying he wants you to do better, Mr. Scheuer. And I believe him when he's saying that he sees a change from when you were raising him and when you were with his mother versus when the divorce occurred and you started drinking again. And that's when it flipped. And that's when the mental health issues, I don't want to say arose, but they grew more intense. And I can see it in the last case in which you were convicted in 24 CF 202 with the individual that you said wasn't your girlfriend, but she thought she was your girlfriend. And that was a domestic abuse incident. It wasn't charged as domestic abuse, but that was a violent act against another woman, against a woman there too, against a person. And mental health issues most likely were involved in that as well. I do believe that you do need assistance, you do need health, you need help, you need someone to provide you with the guidance and the therapy. I don't know how to do it. It's not just AODA, it's not just AA, and it's not just abstaining from alcohol. Whatever happened back in 2003, 2006, and again, then when you started drinking alcohol again, and it started you down a spiraling path, I don't know. Because if you're living on your property, you own 40 acres, and you're living in a tent for a significant amount of time, and then your son has to provide you a camper to live in, and that's through the winters and through, we have hard winters. And if you're living in a camper, that's telling me you're not doing something to get your life on track to be a little bit more stable. I'm glad to hear that you were working at the 10th hole. I don't know if it was full-time. I don't know if it was enough to be sustaining or to pay your bills or to have any property or anything other than paying for your 40 acres. But I don't know what occurred that day, and I don't know what happened that day. I don't know if you really did know or have an idea of if your son's other guns were in your shed. You had a key, and if they were placed there on Wednesday, they couldn't have been placed there on that Wednesday, the November 15th. They couldn't have been placed there that day. That would be too coincidental that they were just placed there that day, and then all of a sudden victim killed herself. That would be way coincidental if that's what happened. But I have nothing to show me otherwise. I have nothing to show me that it was a different day. I have nothing to show me that it was that day. But what I do have is what is in front of me, in that I fully believe you were aware that there is a 22, whether or not it was yours or it was hers or whoever it was, you knew it was there. It is a camper, and it was used for the protection of bears, or at least that is the excuse. But again, there are multiple other ways to protect yourself from bears. I've lived here again my whole entire life. I've lived on more than 40 acres growing up my whole life. We have coyotes, we have wolves, we have bears, we have all kinds of other animals that threaten not only our pets and our livestock, but humans and our children. There are other ways to protect yourself than a gun, especially if you know that you cannot use or possess or be in an area that has a firearm unless it is in a locked, contained facility or place. And I don't believe that was. I fully believe you knew that that was there. And the underlying facts of this case are so extremely serious. They're so extremely serious. And everybody, well, maybe not to the full extent, the defense believes that this is a prison case, but this is a prison case, and I don't believe that you can get the help in the community. I think you would be able to get more help in the confines of a prison system. I first have to look at whether or not you can in the community. But I can't see that you can, because you are the age that you are. It's been going on since 2003 to 2000 and around 2003, 2006. It's 2025. You haven't engaged in any of this on your own. You were put on probation, and less than 3 days later, you had a serious, significant, violent incident that occurred, and you were revoked. I cannot have the community placed at risk. I cannot put you out on the streets without ensuring that you will engage in some types of treatments, and they will address your mental health issues. They will address your substance abuse issues, and that you will have additional oversight in the end. And that means extended supervision. If I were to do that, I would not be doing my job to the best of my ability. And I would be putting the community at risk, and that is what I need to look at, and the severity of this crime. You have a significant criminal history as well. And that comes into play. So I do believe that prison is appropriate in this matter. So what I'm going to do is I am going to sentence you to 3 years of initial incarceration, 5 years of extended supervision. I will make you eligible for the substance abuse programming after 1 year of incarceration. I'm ordering that while in prison, you engage in mental health treatment and mental health programming. You have a mental health assessment and follow through. You have an AODA assessment and follow through. No contact with victim's family. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. If you would like to use any type of weapons, you can hunt. You just cannot use a firearm. You can use a crossbow. You can use a pellet gun. You can use those types of things. You cannot use a firearm. And as far as the knife goes, I'm not the legislature. I didn't write that. Whether or not I think that is an accurate law or how it is written, I can't say. I'm not the legislature. But unfortunately, you cannot even have a knife in a pouch because you're a felon. Cannot even be in a pouch. And this is consecutive to your other sentence. No alcohol, no drugs. So absolute sobriety. Continue with mental health once you are released and on extended supervision. Any outstanding fines and fees will be a civil judgment. You're always going to owe them. You can sit more jail time. Ms. Rocca, what am I missing?
Credit.
Jail credit?
Yeah, he had 6 days on the last judgment of conviction in this case.
6 days of jail credit. What else am I missing, Mr. Keen?
I'm Chisora, but he wouldn't be eligible to vote until after his supervision is completed.
Yep, I said that.
Okay.
All right.
Fire.
All right, if there's nothing else, then we are adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiams.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now, my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to in the matter 23 CV 86 Rick Brimacone et al. Versus Carl Olsiams et al. We're here today in this matter on the motion hearing for Mr. Olsiams. He has filed, I believe, 4 documents that the court has in front of it. He was here in court on Friday, February 6th for the contempt sanctions hearing. And then the court did make a finding that he intentionally and willfully failed to abide by the court's order for sanctions, and he did not meet the purge requirements. So he was brought into custody until he is able to at least meet the purge requirements. After being in custody, Mr. Olsiams did pay the total of $5,000 in the fines assessed against him for the violations. And after that, Mr. Olsiams did send a letter to the court that said, "Dear Judge Mogan, I am sorry, exclamation point. I have paid the fines and I won't rent my cabin again until I have the county permit, exclamation point, regardless of appeal. I promise, exclamation point. I was wrong about not getting the permit and I am truly sorry, exclamation point. I was selfish and not considerate of my neighbors. I ask for mercy and forgiveness," all underlined and capitalized. I have filings and a brief due for the appeal in a couple weeks, so I kindly and humbly ask you to release me today. Signed, a truly repentant and sorry Carl. That was on February 6th. On February 9th, the court did receive another letter from Mr. Olsiams in which he states, "Dear Judge Mogan, I have satisfied all purge conditions and am asking to be released as soon as possible. I came up with the following case law using the law library," and he cites 1, 2, 3, 4, 5, 6 different case laws as it relates to remedial sanctions and summary punitive sanctions. He ends by saying, "I am currently not underlined renting the property. Therefore, there is no continuing contempt. Thank you. And no finding of contempt is possible. Carl Olsiams." Then on February 11th, the court did receive two, what the court would interpret as the actual motions. The other two were just letters to the court with information. On February 11th, the court did receive 2 letter motions from Mr. Olsiams. The first says, "Good morning, Judge Mogan. It's Wednesday, February 11th at 7:30 a.m. and I still haven't been released. So I'm wondering if there is a problem somewhere. On my end, I have satisfied the purge conditions. I have paid the forfeitures, and regarding the licenses, I am not renting the property. Susan, who is his now ex-wife, is the sole owner of the property now, so I couldn't get licenses to rent the property now, even if I wanted to. If there is a problem somewhere with my release, please let me know ASAP, as I need to be released. This is causing irreparable harm. Thank you, Carl Olsiams." After that, the court set a hearing for today. However, shortly after receiving that letter motion, the court did receive another motion, written motion from Mr. Olsiams, looking more like a legal document, and says, "Motion to immediately release Carl Olsiams from custody." In it, he says, "Introduction and argument. Carl Olsiams was placed in custody until he performed purge conditions of his detainment. The purge conditions are to pay forfeitures and to obtain rental licenses from the county and the state to short-term rent the property in Burnett County. Mr. Olsiams has paid the forfeitures. Mr. Olsiams is unable to obtain licenses because as of the date of this affidavit, he is no longer the property owner of the Burnett property and is no longer renting the property. Therefore, the purge condition to obtain licenses for the Burnett property, and he is unable to obtain the licenses." And then the second page, it has certain arguments in which he does place Wisconsin statute 785.04 paren 1 paren B, that imprisonment may extend only so long as the person is committing the contempt, and that the contemptor has the keys to the jail cell. And when he does what the court order wants, or he is not able to perform what the court wants, the releasement must be immediate. Mr. Olsiams paid the required forfeitures on February 6, 2026. As the affidavit states of Mr. Olsiams, this payment is also in the case record. The affidavit of Mr. Olsiams also states that Mr. Olsiams is no longer renting the Burnett property and that he is no longer the owner of the Burnett property. Therefore, Mr. Olsiams doesn't need to and is not able to get the required licenses from Burnett County and the state DATCP rental license. And then he quotes, purge conditions must be feasible and within the contemptor's power to meet, end quote, citing the Larson case. Therefore, Mr. Olsiams has met his purge conditions and must immediately be released. He signed it, Coral Olsiams. He attached an affidavit, or what he believes is an affidavit, to the court in support. It has on top affidavit of Carl Olsiams with the legal caption. He states, I, Carl Olsiams, under oath on Wednesday, February 11th, 2026, state that I am not renting the Burnett property. I am no longer the owner of the Burnett property. I am not able to obtain a rental license in Burnett County, Wisconsin to short-term rent the Burnett property because I'm not the owner. I am not able to obtain a state DATCP rental license for the Burnett property because I'm not the owner. I paid the required forfeitures on February 6th, 2026 for case number 23 CV 0086. Signed this 11th day on February 2026 in Burnett County, Wisconsin. I do recognize that Mr. Olsiam believes that this is an affidavit. It is not a legal affidavit. It's nothing that the court can rely upon for multiple reasons. One, he states, I, Carl Olsiams, under oath, but there is no person that placed him under oath. This is not signed in front of a notary. Secondly, he says signed on the 11th day of February 2026 in Burnett County, Wisconsin. There is absolutely zero signature. There is no signature on this affidavit. It is not a legal affidavit. Moreover, if he was not going to have a notary, the civil laws and ability to not need a notary, that has changed within the last couple of years, and you can do affidavits without the necessity of having a notary, but you must state these exact words. It would be, I, Carl Olsiams, declare under penalty of false swearing under law of Wisconsin that the foregoing is true and correct. It must be dated, it must be signed, and it must have the location. Again, even if he had that required language and did not need to, in fact, have a notary, he failed to sign the affidavit. Therefore, it is not a legal affidavit that the court can rely upon. Therefore, the court needed to have this hearing because all I have is statements made by Mr. Olsiams, and at least to this point, his credibility is not held highly in this court. Can't necessarily believe what he tells me is to be true. And it's been shown time and time again, Mr. Olsiams wants to do what he wants to do, and he doesn't want to listen to the law. He doesn't want to listen to the court. He doesn't want to listen to the county. And if the court does not have authority over Mr. Olsiams, then I'm not sure what's left. Therefore, the court does have him in custody due to the remedial sanction that the court did find, I believe from, is it the August 2025 decision? And under remedial sanctions, I know Mr. Olsiams did want to try and learn the court or have the court learn the law, which the court is already aware of the law and does know how to analyze and read the law. Remedial sanctions, a court may impose one or more of the following remedial sanctions: payment of a sum of money sufficient to compensate a party for loss or injury suffered by the party as a result of the contempt of court; imprisonment if the contempt of court is of a type included in Wisconsin statute 785.01 paren 1, paren B, or paren BM, or paren C or paren D, and the imprisonment may extend, and I'm going to quote this right now, although I'm reading it verbatim, it may extend, quote, only so long as the person is committing the contempt of court, or 6 months, whichever is the shorter period, end quote. Also, another sanction is a forfeiture not to exceed $2,000 for each day the contempt of court continues, as well as D under the statute. Again, I quote, an order designed to ensure compliance with a prior order of the court, end quote. And E under that statute for sanctions, and I quote, a sanction other than the sanction specified in paragraphs paren A to paren D, if it expressly finds that those sanctions would be ineffectual to terminate a continuing contempt of court, end quote. So those are the remedial sanctions the court may impose, one or more of those following. And the court did do that. The court did order that he must pay the fines for each of the counts. The court ordered 45 days of jail per count to be ordered consecutively, or to be served consecutively. The court also ordered that the jail could be purged upon full compliance of the court's October 4, 2024 order, as well as full payment of the fines and fees. That order was necessary as a sanction, not only to terminate the continuing contempt of court, but also it was an order designed to ensure compliance with a prior order of the court, as it has been shown and proven clearly to the court that Mr. Ulsium does what Mr. Ulsium wants, not what is the law requires or states, and not what the court orders him to do. So that order was necessary to ensure compliance with a prior order of the court. And under the remedial sanctions, the imprisonment, if the contempt of court is a type included in Wisconsin statute 785 paren 01, paren 1, paren B, it would mean it would have to be intentional, as it was here, and it would be fitting for Mr. Ulsium's disobedience, resistance, or obstruction of the authority, process, or order of the court, which again, here in this case, because the court did find that he engaged in intentional disobedience, resistance, or obstruction of the authority, process, and order of this court and this court's order. So that's why the remedial sanctions were ordered exactly the way they were ordered and why they were ordered that way. As it relates to whether or not the jail sentence can be concurrent or consecutive, the Wisconsin statute 785 says nothing about contempt sanctions, whether they can be served consecutively or concurrently. However, the legislature has given the authority to the court's inherent power in this area to impose sanctions as the court deems appropriate. And that is exactly what the court did. The court deemed the jail sentences 45 days each, which is very reasonable in light of the fact that the court could have done something more, and did have it be consecutive. This was not a punitive, as in a summary sanction. This was a remedial sanction. And under remedial sanctions, the court may also provide a sanction to stop the past conduct so it does not continue in the future. In this case, the court does have Mr. Ulsium's continuing to rent the property. He rents it for whatever period he rents it for, then he stops, then he rents it again, then he stops, then he rents it again, then he stops. So although Mr. Ulsium has argued, and I'll let him fill the court in as to his argument and what he wants the court to understand and to consider, he believes, at least how I'm understanding, that when you rent then you stop because no one's renting, that stops the contempt, and then you rent, and then you stop, that stops the contempt. However, remedial sanctions are in place for situations exactly like this, which is ongoing conduct, which is conduct that continues for a particular time and stops, and where it's called, I believe, intermittent type of conduct or reoccurring contempt. And so that is exactly what happens in rental situations such as this. Therefore, even though there may be contempt for a rental period, it doesn't necessarily stop because no one is renting the next week. It is a continuing, reoccurring contempt. And there is certain case law as it relates to this. In one particular case, it emphasizes that remedial contempt, refusing to comply with the court's order, the sanction must be designed to terminate the continuing, reoccurring contempt. And that is exactly what the court did do in this case. And there are a couple cases that do follow suit with that. However, I did want to have this hearing so that I could allow Mr. Olsiums to be heard, because he does make statements, although he didn't make any statements at the time of the February 6, 2026 hearing, that he no longer owned the property, that he was divorced from Susan, and that she was awarded the property. He made zero statements that would even infer that that was the case. And in his first letter to the court apologizing, where he indicated that I won't rent my cabin again until I have the county permit, regardless of the appeal, I promise, leads the court again to believe that the property, the cabin, is still his property. As he states, it is his property. In the second letter, he says, I have satisfied all purge conditions and am asking to be released as soon as possible. But he did not at that time, because again, he made no statements that he no longer owned the property, that it was awarded to his wife during the divorce. So at that time, he still did not meet the purge conditions, because he still did not comply with the court's order, applying for both the state and the county short-term rental permits. It wasn't until February 11th, in which the court did receive those two handwritten motions with the non-authoritative or legal affidavit, which he does tell the court that he no longer is the owner, that Susan is the sole owner of the property. That is where the court then did have the need to set the hearing so that the court can understand if he in fact is an owner, if he isn't an owner, and why he didn't make any statement on the February 6, 2026 hearing, because that could have easily fixed all of this time that he has sat in jail, because there was nothing that the court had in its information or evidence or statements by any party that he no longer owned the property. And again, it wasn't until February 11th, 2026, in which the court had any inclination or any reason to believe he may not continue to own the property. So the court, upon receiving that motion on February 11th, set the first available hearing date and time that the court could set to let this matter be heard, to provide notice to the parties, as well as to fit it in the court's calendar. So Mr. Olsiums, I am now going to give you the floor for you to argue to the court what you want the court to know, and why you believe you've met the purge conditions. But first, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Olsiums, you may begin.
Well, again, Your Honor, we're here because I'm requesting immediate release because one of the purge conditions has been met and the other purge condition is not feasible and is not purgeable because I don't own the property. Again, you made a comment on the February 6th hearing that I didn't mention that I don't own the property. I kind of felt like I didn't get an opportunity to mention that.
Mr. Olsiums, so you know, I have read all of the, it's called real time, where my court reporter takes down every single word that's said. It's not a legal transcript, but it's real time, so I can see what's being said in case I missed something. I have reviewed every single statement that was made in that hearing. You had plenty of times because you kept saying my cabin, my cabin, my cabin, my cabin, multiple times. So at any time during that hearing, you could have said, I don't own that cabin anymore, but you didn't. And again, I've read it and it's like 95 pages long. So not one time did you say that. So I would think very clearly about what you're saying to the court. That's easily checkable because you are under oath.
Yep. Okay, so again, the forfeitures have been paid. Now regarding the licenses, the divorce decree was final on November 7th of 2025. Suzanne was.
I'm going to let you know the court. Go ahead. Sorry.
Okay. So again, the official final divorce decree was final on November 7th of 2025. So we're waiting for the final decree to come out about whether or not to apply for these permits. The divorce decree comes out on November 7th, and Suzanne is awarded sole ownership of the cabin in the decree. And that's again on November 7th, 2025. Suzanne then recorded a new deed with Burnett County in December. And if you look online, you will see that she is the sole owner.
Well, I can't just look online. I actually will need to get actual documents of that.
Well, I actually have the document on my phone. Yes, I do.
I can't take your phone. And I don't have your phone.
No, I know that, but I have the document on my phone.
Okay, I have the ability to, just so you know, I have the ability to be able to get a copy, but I don't now. I need to hear because quite honestly, when I reviewed and read your motions, I didn't believe you.
Okay, well, I'm sorry you feel that way, but again, this is all verifiable fact. I'd be pretty big stretch to say that this divorce decree didn't happen and that she wasn't awarded the sole custody, sole ownership.
And for the record, Mr. Olsiams, I do believe you now because based upon your motion, I am taking judicial notice of County of Washburn, State of Minnesota, Family Court Division, court file number 82-FA-24-3716, in which I do have a full stamped copy of your divorce. I was able to get that online with or with court records. So I was able to get that. So I could read, and I'm going to let you know, I did read and she was awarded that, but I don't have, I need the proof that it is no longer in your name and that you are no longer going to be associated with it in any way, shape, or form.
And I have that. It's on my phone. Her attorney, I actually subscribe to a service that when somebody makes an entry on your property, I got an email. And I saw that her attorney had filed the divorce decree and stating that I was the grantor and she now has sole possession of the property. And I have a copy of that on my phone because her lawyer sent that to me. So I just need to get the document off of my phone to give you a copy of the actual recorded document that he did with Burnett County.
Mr. Olsiams, and also, do you understand what I said about your so-called affidavit and what's wrong with it and why I couldn't even rely on it?
Yeah, yes, but I'm sitting here and I have no access to any resources here. I had to plead for a pen. There's no resources in here to do that. So I just kind of at my best recollection.
And that's fine. That's fine. And I get that. But the number one thing is you didn't even sign it.
I thought I did sign it though.
Nope,
I think
you did not. I have it right here because my job is to go over things with a fine-tooth comb. And I know you can't see it, but you didn't even sign it. It says right at the bottom. Signed this 11th day of February 2026 in Burnett County, Wisconsin. Zero signature, big circle question mark, because zero signature. There's no signature on it. So even
Well,
if I
apologize.
put the under oath thing aside, I don't have a signature.
Well, I apologize for that. Again, I limited resources here, and I just, based on my best recollection that I could, I put together that affidavit to give the court some kind of an official reading in the record that I'm no longer the owner of the property.
I get it. Limited resources doesn't mean you lost the pen as soon as you wrote the sign this 11th day of February and you couldn't sign it. That's not limited resources.
Okay, well, I apologize. I can create another affidavit. If the
I
court
don't
wants
need
to.
it now. You're under oath. I'm getting the information that I need. I put you under oath. And so I'm gathering the information that I need. And again, I took judicial notice of your Minnesota divorce case, the findings of fact, conclusions of law, order for judgment and decree. And so I read it. I read all, it's very long. It's one of the most lengthy findings of fact I have ever read in my life. It is, they don't label the page numbers, unfortunately.
Would you
It's
like
very,
me-
very lengthy.
Would you like me to get you a copy of that official recording that was done at
No,
Burnett County?
you can't, you don't have your phone. And you won't be able to print it and give me a copy. I have ways I can do in order to get it, or I can get a copy of it. I'm not worried about that. I just want to know now that you're stating that it was awarded to your wife. I confirmed that. And that you're telling the court that it was legally transferred to her name only.
That's correct, and that happened in December.
Okay, so I can look at that.
Yes.
All right, what else would you like me to know?
So then again, just technically the forfeiture purge has been satisfied. The license purge condition is not feasible because I don't own the cabin. And again, on the Larson case, the Supreme Court said that the purge conditions must be feasible and within the contemporar's power to meet. Obviously, if I don't own the property, I can't get a license. So that purge condition then is really irrelevant or moot, or because Suzanne now controls the property, not me.
Yes, and I need to get proof of that, and that's where we are. And I appreciate the fact that you went to the law library in the jail and that you found a book or something, and you wrote down all the case law and all the brief summaries of the cases. I know the law, Mr. Olsiums. I truly know the law. When I got your first letter, you didn't meet the purge conditions. When you got the second letter, you didn't meet the purge conditions. It wasn't until the third letter that I had any inkling that you may be unable to meet the purge conditions. Okay. And then with the additional motion, that's with the affidavit. If it was a signed affidavit, it would be stronger in the court of law, but it wasn't. But again, the 11th was the first inclination that I had that you may not be able to meet the purge conditions. And so that's why I needed to have a hearing so I could hear it from you. It wasn't signed under oath, or it wasn't signed declaring penalty of perjury or sanctions of the court. It wasn't signed at all. So anything else you want me to know?
Well, just that I'd like to be released immediately. I have a number of matters and affairs that it's causing irreparable harm. And I need to be released immediately.
I appreciate that, but your continuing contempt, your reoccurring contempt, your ongoing contempt, your intermittent contempt, all of that causes irreparable harm to the plaintiffs in this case, as well as to the county and the state, because you're not doing what you were ordered to do. So I get your argument of irreparable harm.
Right, so I don't own the property anymore, so I can't meet that purge condition, so
okay.
That's why I should be released.
All right. Mr. Anderson, I'm guessing you're here just because you're a part of the case. I don't know if you have anything you want to argue to the court.
Your Honor, I don't have anything I want to argue. We are not taking a position, but I would have one question for Mr. Olsiums, if that's okay.
I'm fine with it. Go ahead.
Mr. Olsiums, is your divorce decree Are you appealing that decision from the court in Washington County, Minnesota?
Oh, I can give you that information too. He's already appealed. It's been denied because he was late. It's been denied twice by the Court of Appeals. I have that attached to this findings of fact as well.
Okay.
Those
Thank you.
are, I should have went over that too. Sorry, Mr. Anderson, I don't mean to rain on your parade.
No, that's okay. Just information.
But I do have State of Minnesota and the Court of Appeals case number A26-0006. It was dated, oh, it's so hard, January 12th, 2026. How Minnesota does their stamps and things, it's very different from here. And I forgot from my practicing days. Anyway, it goes on to give a number of statements based upon the file, the record, and the proceedings. And because there is a question whether this court has jurisdiction, in the end, the Court of Appeals states that his filing was untimely, and it says applicant's failure to file a jurisdiction memorandum may result in such sanctions as the court deems appropriate, including dismissal of the appeal. And then there is another order. It is not, again, they don't even write as clear as we do here. Another order that says, oh, wait, nope, that other order does, the first order said that he didn't do what he needed to do, and he wasn't in compliance. And then the second order said jurisdiction over this appeal is accepted. So it is in appeal right now.
Okay.
Anything you want to have him state after that, Mr. Anderson?
Well, I guess the only other question I would have then, if so they accepted the appeal, it sounds like. So then the question would be, Mr. Alciums, are you asking that the cabin in Burnett County be awarded to you on appeal?
Yes or no? It's a yes or no.
Yes, yes.
So,
Oh.
Your Honor, again, we're not taking a position on his request to get out of jail, but the concern, of course, on behalf of my client is that, well, he may not be able to have satisfy the purge condition now, but it's something that'll come up in the future if, it's a big if, but if the Court of Appeals or if he is awarded the cabin in the future.
Mr.
And again,
Anderson,
Your Honor,
I will point you to that findings of fact, and it is a very good read. I'm going to highlight some of the important things on the record now because it is very applicable to this situation. But Mr. Alciums wanted to say something first.
Yeah, just that, Your Honor, whether I end up with the property back in the future, and if I do end up renting it, as I stated on my letter, I will get the necessary permits from the county and the state if I'm ever in that position again. So,
Okay.
again, I've learned my lesson. I give my apologies to the court. It's kind of a flaw of mine, my personality. Kind of pig-headed and stubborn. So again, I just want to offer my apologies to the court. And again, if I do end up in the position of owning the property again and wanting to rent, with Scout's honor, I will follow your orders and get the necessary permits. And to the neighbors that are listening, I respectfully apologize. Again, in my mind, I didn't think I was being offensive with the rental activity. It was everybody's been behaved. I don't think the police have ever been called. I have strict rules of people that rented. And I, believe it or not, I did think in the back of my mind of when I rented my property to respect the neighbors. So I don't think there's ever been any loud noise.
Well, we did go over all of those things and they were very detailed in the court's October 4th, 2024 order.
Right. Well, I'm
And
saying,
then again in the August order, I believe. August 2025 order.
Yeah, so just, there's never been any loud parties and, you know, there's rules and a contract that says if there's penalties for that. So I think it's been pretty respectful and, but again, I understand their feelings and, I understand their desire to have, that go through the county. So again, if I'm ever in that position, again, I will, you know, get the necessary permits from the county and the state.
All right, thank you, Mr. Osiums. And to kind of swing back, the loud parties, those things, that wasn't any main argument of any of the plaintiffs. It was the fact that you had 14 to 20 people that were staying at the property at the same time, that it took up not only your parking spaces in your property, but all along the side roads. And that is a very tight space. And that if you were to have complied and done what you needed to do, because you did rent over the 10 legal nights per ordinance, if you wanted to rent over the 10 nights, as you did, you needed to be compliant with state law and county ordinance and have your permits and your licenses, which you didn't. And if you did have those, that's where the county and the state come in and they say, you know what, this is the square footage of the house. This is the number of parking spaces. This is how many people you may rent to at a time. This is how many vehicles you may have. Because again, the off-site parking or not in your parking spaces is, again, one thing that the county looks at with short-term rentals. So that's the main argument there. But I appreciate your apology to the court, Mr. Olsiums. And I do understand that your argument is it's a negative characteristic trait of your personality. When I look at the divorce document, there are certain things I want to highlight, and because again, it affects Burnett County, it affects credibility, it affects whether or not the court does trust that you're going to abide by the court's orders. Page 3, so some of the decree is numbered, but page 3, paragraph 11, it talks about discovery, and it says that you were served discovery in a formal discovery request on March 17th, 2025, and you were asked to provide certain proofs of income, earnings history, social securities, list of interest for bank investment accounts, retirement accounts, real estate values, those types of things. And it says that respondent neither responded to the formal discovery request, nor did he provide the requested information, and that is to the court. Petitioner through counsel has complied with all informal discovery requests from respondent because you served discovery upon your wife or ex-wife, and she complied. You failed to comply. And here's where the court states that the court takes a negative inference against respondent for his failure to comply with discovery, including his failure to provide information to support his claim for spousal maintenance, non-marital claims, and asset valuation, because you didn't provide those things. And you did have a historic income that could be stated of, I believe, because you were a contractor, you did multiple different things, between $250,000 and $500,000. You had monthly expenses in the amount of $4,081 for all of your living expenses. Every piece of your living expenses, that was your monthly living expense amount. And yet you requested spousal maintenance from your ex-wife in the amount of $4,000 a month. The court did deny that because based upon your work history, you are able to be self-supporting and you did not comply with any of the court's orders or the petitioner's formal requests for discovery information. And so again, the court did take adverse inference against you for your failure to document your income, earning history, employment, and income capabilities. And they cited Minnesota case law that says that a negative inference does go against you for failing to comply with those legal requirements. It does go on and state that while you were married, you both were frugal, and that's a good thing. I am a frugal person as well, and I think that's how you can be able to save more of your hard-earned money. And you took frugal vacations that included reduced cost cruises, cheaper hotels where you're able to make your own meals without having expense to dine out. You lived in nice houses, but they were built to resell for income, and you kept the same furniture. Again, commendable, but that your ex-wife could only shop at stores of Walmart, TJ Maxx, Goodwill, and that she was only allowed to get 2 to 3 haircuts a month, but only at Great Clips. She could not get her nails done. She could not get her hair dyed or anything else like that. And she could not have or wear expensive jewelry. That you do have multiple properties, one worth 4.5 million, 2.8 million. And that on your homestead, the 2.8 million, that you only owe 365,000 and change for your mortgage, but that the mortgage was significantly reduced due to your ex-wife and her payments that she made when she was out of the home so that it would not go into foreclosure. That your Burnett County property has a high value of 741,000, and that it was awarded to Susan pursuant to the divorce decree. That does not have any significant mortgage on it. However, the property is encumbered by 4 civil judgments. Burnett County Judgment 18FJ04 in the amount of $67,395 for Edina Realty. Burnett County Judgment 21SC179 in the amount of $25,119 for the Burton lawsuit. And Burnett County Judgment 23-CV-86 in the amount of $212,306, and that they were awarded your sole responsibility. And even though they are attached to the property, that you must solely pay that, and in some type of payment to your ex-wife that was to be due by February 7th, 2026. You have multiple other judgments in other counties in Minnesota as well as Wisconsin, and those are awarded solely to you for your responsibility. And that with the Burnett County property, again, it was awarded solely to your ex-wife, Susan, based upon the equalization of the property, which does include an equalization payment that she received this property plus some other things, but you still owed her that equalization payment of $1.55 million, again, to be satisfied by February 7th, 2026. And again, all of the other judgments are your responsibility in all other matters, shapes, and form. And then you did appeal, and the first one was denied, but then the second one, they did say that if you follow and you do all of the things that you need to do for the appeal, that your appeal will be accepted and it will be heard. But again, you have to do all the things that you need to do by whatever deadlines that they have. So that's the information on the record. As to why it's hard to judge your credibility, Mr. Bolsiams, not only from all of the statements that were made in court and proved not correct, but in the fact that you were found in contempt many times. But at the last hearing on February 6, 2026, the court did ask you about the payment for the transcript that you did owe to the court reporter, and the fact that that was a lot of difficulty for the court reporter to get the transcript. You indicated on the record that you paid that amount by Venmo in the morning. However, then the court's order went out in the afternoon, but that wasn't correct. And the court said, it's easily verifiable. There's records of when payments were made and when orders went out. And you said, yes, I paid it by Venmo before the court issued an order. That's not correct. That was. I said
I made the payment today. I said I made the payment the same day as your order.
Yep. And I have, again, I can read it from this real-time transcript, what you said. You did say that, but then you also said, I paid it before the order was issued. You said that multiple times in this record. If you want me to go over and read to you what you said, I certainly can do that. But you said, I paid it before the court issued an order. That is not correct. In fact, that was a lie because the court issued an order, and then it wasn't until many hours later that you decided to violate the court's order and pay by Venmo when the court ordered strictly only payment by cash or check to the court reporter. And you paid by Venmo. Again, doing what you wanted to do and not what anyone else told you to do or ordered you to do. Again, with the whole credibility, this was brought up in another hearing, but the court did get the confirmation of it with regards to when I was looking for the findings of fact. The 10th District Judicial District criminal case in which you were convicted of multiple felonies and you were sentenced to 23 months in St. Cloud Prison, but it was stayed for 5 years, and that you must serve 45 days of that in the Washington County Jail, which you did. And the fact that you were convicted of, I believe it was 14 felony counts for swindling, tax evasion, or theft by swindle, tax evasion, and other multiple felonies. And so that goes against your credibility as well. So again, can you see why it's hard to believe your statements that you do not own the property, and the court needed to find assurance that you did not own the property, but I do not have any documentation that it was yet transferred to Mrs. Olsium, or I don't know if she goes by Mrs. Olsium's anymore, but Suzanne. So I need to get confirmation that it was transferred to Suzanne's name only before I can see if you're unable to meet your purge requirements. And it's good to know that you are appealing, and that is part of the appeal, even though I believe that the findings of fact is very thorough, very well written, and goes over all of the information necessary for the Court of Appeals to make a decision in the case. So based upon that information, the court is going to get confirmation that the document or that the property was transferred to Suzanne and her name only from the Register of Deeds for the title and the ownership. And after I do that, I can make the determination of whether or not you are even able to continue to meet the purge conditions, or if you are unable to meet them due to the reasons stated on the record. Is there anything else you would like me to know, Mr. Olsiums?
Just again, if I can just facilitate, I have a copy of that document. Again, I'm just requesting to be released as soon as possible.
I can't release you. I can't release you until I have that documentation. And so it's kind of a catch-22, isn't it?
That's why I'm asking, I don't know if you can give me special permission just to get that document off my phone. I'm sure the people would.
I can't, that's a jail policy. I can't give them an order to give you a phone because their policy is not to allow inmates to have it. But I do want to state on the record, Mr. Olsiums, I appreciate your statement and your confirmation that you do recognize that the sanctions order was necessary to stop the continuing contempt, and that you are going to abide by the court's order if and when it is necessary. So I do appreciate that. So I will get the information I need, and I will get an order out as quickly as I get documentation, and then we will see if you're able to meet the purge or you're not.
I'm going to ask the captain here if he'd let me get my phone and take that document off. I can zing it up there as soon as possible.
Well, I'm going to say again out loud here on the record that I don't need you to do that. I have the ability to get that document. So
Okay.
There's no need for the captain to give you special privileges to use your phone when no other inmate has the privilege to even touch their phone.
Okay.
So we'll go there. All right, now I'm significantly behind on my calendar, but I will get an order out and make my determination after I receive the document.
In this courtroom, the judge was faced with a decision that could completely change the direction of a serious criminal case. A plea agreement had been presented, but after reviewing the allegations and the information available to the court, the judge made it clear that this was not a routine decision. The case involved allegations of extremely serious crimes that, according to the judge, caused significant and permanent physical and emotional harm, including emotional harm to a juvenile. Both the prosecution and the defense had reached an agreement, but the judge reminded everyone of one important fact. A plea deal is not automatically binding on the court. The judge has an independent duty to review the agreement and decide whether accepting it would truly serve the public interest. The judge carefully explained that when a plea agreement includes reduced charges or sentencing concessions, the court must look beyond the agreement itself. The court must consider the seriousness of the alleged offenses, the harm caused, the potential danger to the public, the interests of the victims, and other circumstances surrounding the case. The judge emphasized that every case is different and that the court must balance the arguments made by both sides against the broader public interest. This was not simply a matter of accepting an agreement because the attorneys had negotiated one. The judge had to make an independent decision based on the information before the court. As the hearing continued, the victims' wishes also became